What is up, guys? Welcome back to Truth and Transparency. Kirk coverage here. Tyler Robinson preliminary hearing. Last day. Well, what a day, day 4. We're going to watch this on Law and Crime Trials so long as the audio is fine. We'll see. Let's take a look at checking in with Twitterland. I'm doing this against my better judgment, by the way. For example, Court TV put out just 2 minutes ago, full interview. Tyler Robinson's lover spills, in all caps, alleged confession. Ridic. Sure. Lance Twiggs reveals evidence of remorse in Tyler Robinson hearing. MK True Crime. We've got hella shit going down in the Karen Reed. I'll be covering Karen Reed, Turtle Boy, later. Karen Reed's team made a huge blunder. When do they make the decision if this goes to trial? I'm guessing today. Who knows? He says he could take his time, though. So, whatever. I was like, oh no, she decided not to live stream it today. No, I'm not a quitter. You know, I did it all week and to say, yeah. I just couldn't hear any more of the bullshit. Let's go on over Twitter. Let's see what's going on. Oh, wow. Yesterday, Karen Reed's anti-SLAPP motion appeared on the docket, and in a stunning, unbelievable procedural gaffe, Miss Reed and her team served her motion on the wrong pleading. Out of courtesy, the plaintiff attorney, Karen Murphy, alerted Reed's team to their monstrosity of a mistake, a courtesy they were not required to extend. And instead of addressing the error, Reed's team replied with arrogance. If you have not yet read the Reed motion, I would suggest you first read the declaration of Karen Murphy, docketed after the plaintiff's opposition, and be sure to review the email chain attached as an exhibit. The emails read in reverse order, so scroll to the end and read up to capture them in order. Oh boy. Counsel, we intended to file a request for default pursuant to Rule 55A against Karen Reed in the defamation action today. Defendant Reed appears to have served a motion to dismiss inoperative pleading related to the closed Barnstable County Superior Court action and has therefore failed to respond to the operative allegations in the first amended complaint pending in Plymouth County Superior Court. For this request, we are not required to confer pursuant to Rule 9C and are able to file this request outside of the normal 9A process. However, as a courtesy, we are available for a conference this morning should counsel for Ms. Reed prefer to have one prior to our filing. Oh my God. 43 minutes ago, Candace Owens says, there are so many devastating points to the Tyler Robinson narrative, but chief among them is Lance Twiggs testifying that Tyler wasn't political, didn't ever speak to him about LGBTQ issues or gender identity issues, and also alluding to the fact that he is not trans. He goes by Luna, but he says it is not a female identity. Likely some gamer or anime stuff. Oh my God. He's like, my name isn't Luna because I'm a les. I want to be a les or I want to be trans. It's because that's my. He's not trans. He's a moon. You guys, I can't this morning. For months, Satanists have been trying to convince you that Tyler was so motivated by politics and trans ideology that he decided to murder Charlie Kirk for trans viewpoints that Tyler held so dearly. He never even expressed them to his boyfriend. I'm sorry. Until a stunning text message confession after the murder, shown to us via a picture on Lance's phone, which just happens to be smashed in the very corner that would allow us to verify what time these photos were taken. This is all very dangerous, says Candace. The government is playing a very dangerous game here with this trial. The illusion of democracy and a social contract is being completely evaporated. We are not supposed to know that our government is capable of this level of violence and psychological delusion. Oh, shit. The thing that's crazy about it is, so she shares Sam Parker, how absolutely unfortunate that the damage to Lance Twig's phone screen is a nearly perfect circle exactly over the time display on the left-hand corner. You know, so last night I didn't go to bed till 4 in the morning. Why? Well, because I read 1,045 pages of stuff last night. Because I just felt it was so important. I was live last night, and then after that, I wanted to read, Cyray's reports available, and so is there's a couple different reports that are available now. And those of you guys that have been following my work with the Idaho 4 case, I'm all about this data and the digital footprints of people because of what the capabilities are. And I about barfed when I saw that in the Idaho 4 case, the state never has to this day done any work with anybody's phones to create a timeline of where they were when they were there, pattern of life, that has done nothing of it. And something of this nature in that type of case is something that you would do. Same thing with Tyler Robinson, this type of a case. And just to hear that the stuff that Cyray put in his report is just, he reiterates, I don't even know, 70 times that this was deliberate acts and this was all intentional and these were bad actors. And so, and I knew what his report was going to say. I knew what his report was going to say. And his report was everything that I had thought it would be. And then just to read this fucking book makes you want to puke. His book, Cyray's book. I mean, Matt Nodals. Let me see. Cyray. So, Lana, why does that matter about the Tyler Robinson case? Well, because it's just the same thing. It's, where's all this data? Like, I mean, these FBI agents deliberately fucked with cell tower maps and coverage areas and lied about them, and then doubled down when they got caught to then try to fix it from a draft report to like the final report. And also was peer reviewed by the same person that was working on the case. And that level of corruption, the FBI did it. And he calls it out in all of his pages that he did with this report. And his report was wrote before his affidavit was wrote. And why that's important, if you were following the Idaho 4 case, is because this is when they realized we need to muddy up the waters of Cyray. Because this was written in January of 2025. January of 2025. and then everything happens after that. So they would have been in, the question is when was this provided to, because Cyril wrote it on in January. When was it then provided to the prosecution, to the state? And when you would read this, it's like he's taking us down. And he has, I mean, he doesn't hold anything back. He has all the evidence to prove what the fuck they did. And he lays it all out in this 51-page report. And to see what they did and how they manipulated the evidence, and that, I mean, and to know that Nick Balance did it, and that's the person who did the Lori Daybell case and the Chad Daybell case and whatever other fucking cases he's done. But this work alone, if there would have been a trial, would have brought Daybell, both of their cases back in, and they would have, I mean, they're looking at appeals. So then one has to ask themselves, why the fuck would you ever go write a book and say that there weren't bad actors when you are saying the words that this rises to the level that this is an intentional manipulation of the data, in quotes. It is my opinion that this oversight in the analysis is an intentional manipulation of the data. This is impossible given the magnitude of this investigation and the importance of the data at this time, that you would ever make the mistake that the phone shut off at 2:47, in fact, when it was 2:54. This is not only a misrepresentation of time, but a concealment of critical connections the mobile device makes between 2:47 and 2:54. And it was all omitted. And the much larger issue is that it was all omitted to make probable cause, to not only make probable cause for the arrest, but before that to ensure search warrants were happening. To see that you could actually, the FBI CAS utilized and made a huge lie saying that the CAS Viz and Gladi are mapping programs to create work product. Neither is affiliated with Google in any way, yet they're testifying like Mowry did, saying that's a Google map and shit like that. And that's not Google Maps. In fact, Cyril says the maps used in Special Agent Balance's report is actually a mapping software called MapTiller from OpenStreetMap. This is a company completely unrelated to Google. It is unclear why Special Agent Balance chose to qualify his mapping as a Google-based mapping program. They methodically went through and cherry-picked data. I have seen no evidence of a complete geolocation analysis in this case on behalf of the state, but rather a manipulation of raw data to create a false timeline of events. One cannot dismiss this error as oversight. To make such a claim, one must ignore all accepted principles of CDB geolocation analysis or omit critical data from the AT&T CDRs. This is the result of a user error in the drive test process. I mean, everything is just, you cannot, this is every single aspect of what they did with the data and how they manipulated it. Rolanna, why are you bringing up this? Because this was such a high profile world case, and these fuckers did it all in front of us. This case is no different. The Tyler Robinson case is no different. This is all in front of us, right? And we're trying to get transparency. We're trying to get everything. And the one thing that they did not bring into this courtroom is any of the digital data. Mind-blowing. The last case, it was like, I felt like on this type of a level, is the Idaho 4 case. The FBI did not just like lie in reports. They made up fake coverage areas for cell tower data and told the world that Brian Culver's phone was consistent with being on certain cell towers based on the coverage. Cyril had to independently do 500,000 data points himself and just checked it all. And he said it was very tedious, very long. It was over hundreds of hours to do this work. But when you're talking about falsifying cell map coverage areas, and the way that they did it was they lied about what the GAR machine did. And he's like, they're saying that there's coverage areas that aren't even accessible to a person driving. That's how fucked what the state, what the FBI did in the Kohlberger case. And so when I see the parents in the Kohlberger case, and I'm like, do you fucking read this shit? You think it's all just lies? Because guess what he did? Syray used the state's own fucking data. Their
clarity regarding the expectations governing today's proceedings. Could you both please state your roles for today's hearing?
That's crazy to me.
My role is to capture full photography, still photos.
And so here we are again.
For video in accordance with the court decorum order.
And I apologize. Would you mind putting your names on the record?
Tess Crowley.
We're supposed to sit here and listen to this shit and believe it.
Court standing decorum order.
Yes.
Do you understand the requirements set forth in that order as it applies to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
Oh, he said that they're corrupt.
Do you anticipate any difficulty complying with the order?
No.
All right. Thank you both. Before we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the...
You guys, I feel like we're at church and it's just like the beginning, and they have to just read from,
solemn obligation to protect and uphold the constitutional rights of Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone or electronic device in the courtroom may be addressed by the court. For those individuals who have a cell phone, I invite you to join me as I silence my cell phone to ensure that the proceedings today can proceed without distraction. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with this court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or of other visible reactions during the hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case, or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, and orderly, and faithful to the rights and dignity of every person involved. All right. My understanding is the parties wish to address an issue before we get started. Is that correct? Mr. Novak.
Thank you, Your Honor, and good morning. I passed up to the court after providing copies of it to counsel for the state and counsel for the media, a single piece of paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning, this court has a colloquy with the camera operators about their ability to comply with this court's orders. And they acknowledge that they understand the order and that they can comply with it. And the court asks them if they have any problem with it, and they state to the court that they do not have a problem with it. We also spent many, many, many hours of court time addressing which exhibits will and will not be published through the electronic media. And this exhibit, the court ordered would not be published through the electronic media, and it was. And without belaboring the point, the court can imagine our concern that the media and the state who control this exhibit and the publication of this exhibit in the courtroom as per the court's orders failed to comply with this court's orders after all of the effort that we made and the court made.
Yes, I will.
To make sure that the court balanced everybody's rights, including the rights that we're concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error.
What?
But it's done. It's out there. It's photographed. I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office. Obviously, I'm not going to do that. But my point is,
you're a fucking
it
idiot.
doesn't matter how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just wanted the record to be clear that we're concerned that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
Is there a requested remedy or potential sanction that you feel is warranted given the
Nothing.
actions which you have outlined this morning?
I think that we would like to think, when I say we, I mean Mr. Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding.
It's actually
of
helping
any
your
of the
clients
proceedings
shut the
and
fuck up.
specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature, but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak,
The gospel
I
of the
appreciate
Lord.
that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait until
Thank you.
this. I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Oh,
Okay.
I don't
I just
want to
couldn't
sit on
sleep.
this. So I ask you respectfully to confer with your counsel and come up with that, because I want to address it. I agree. It is concerning.
oh,
And
stop.
it
You know what's
warrants
concerning? Your
examination
fucking
and to be
lies.
addressed immediately, especially as we have a little bit left of our preliminary hearing. So I want to give it the
No, you know what's concerning is all these fucking lies. That's what's concerning. All this bullshit. The fact that this took 10 months to come and be here and doing this. 10 months. Shame on you, Utah.
weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence? We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be. And we can bring that suggestion back to the court in a few minutes.
All right. Well, before we do that, I want to turn to the state and to the media to address what you've addressed. And then obviously, if there's a part two, then therefore.
And I appreciate the invitation, and I also appreciate the court's desire to address the consequences, if any, immediately.
Thank you, Mr.
I was not
Novak.
trying to delay it. I just think it's an issue which warrants some thought. The court
Wow.
said it gave it some thought. We will have a suggestion very briefly.
Thank you. Turning to the state.
Thank you, Your Honor. I think at the outset, it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published before the exhibit at issue was also brought onto the screen. I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera was captured this for approximately 2 seconds. The camera operator, I think, acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down, and as soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved.
VAR, VAR, VAR. You guys, this is like a penalty situation in the World Cup, okay? Let's go to the VAR. Let's go to the screen. Let's go to the replay monitors. Let's see if there was a foul. Should we give them is there a red card? Is it a yellow card? What do we got going on, guys? It's wild down here Friday. Everybody is tailgating. We have the World Cup at 3. And right now, Judge Gaff, Tony Gaff wants to go to the VAR. Let's go replay it.
Involved here made quick and appropriate efforts as soon as they realized the mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because the requirement for timely objections. Moreover, I do want to say this exhibit.
This is an accident. There's nothing
was read
deliberate
into the
here.
record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with
Thank you, Sassy.
a lot of publicity when it comes to media coverage. And I think that's really where the
This is just laughable.
Addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing. But I think ultimately that's where this will be addressed.
Why do I bother starting at this time?
Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when the defense comes back. I want to weigh this and taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that
Live streaming.
purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but
Yeah, it has.
That's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it. If you
It was a partial exhibit because we didn't even get the bottom part. So oral argue correctly. It was a partial exhibit. God bless it. You fucking all suck. Okay.
sequence was any different. I just want to make sure
This is a
clear record
partial
is
exhibit.
being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory. And I also reviewed the video, the live stream as well in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media. And so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. To the media.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand them. There's 2 exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those 2 exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all three of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that three-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit, and recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire, and we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live screen, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control. And that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are. But then on March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen, but since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there.
This is a partial exhibit, and it is the goddamn fucking letter that was the, hey, go underneath my keyboard and pull this shit out letter, okay? That got accidentally shown on the screen for 2 seconds, and it was partial. It wasn't even the full letter. I immediately took a screenshot of it. I have no problem admitting this. I did something legal and I screenshotted it, and so did so many other people. They went back and zoomed in and tried to get the best view, screenshotted the fucker, enhanced the fucker, and shared the fucker all over Twitter, all over YouTube. I sent it to every one of my contacts in my phone. Just kidding about that. Who gives a fuck? Okay? This was an inadvertent mistake, not by the media. Okay? We have humans. Can you believe that? Humans are actually fucking working And humans can make mistakes. It's okay. It's okay to make a mistake. Teach your kids that, God damn it. Make mistakes. That means you're trying. Don't be afraid to fail. Fail as many times as you want. If you don't try, you can't even fail. You can't even succeed. You have to try. You cannot be afraid to fail. So here, a stupid letter was shown. That's what they're going on and on about. And it wasn't even full. It was partial. And that should tell you how immediately it was corrected, because if it was, let's fucking, be so nefarious here, the camera would have stayed on and would have got the rest of the exhibit. So this is the stupid letter that was left underneath the supposed keyboard. Well, guess what? The letters out there and those S's look exactly like Lance Twiggs and the way he writes. We don't have any samples of Tyler Robinson's hand. I bet you I can probably get some of that, though. I think I just thought of a way. But he basically, the way this letter is wrote, the way that he engraved the bullets was in better handwriting than this fucking letter in pen. Please. But this is just ridiculous. This is ridiculous. And this is what the 2027 world looks like now. Bunch of fucking softies.
I only want to reinforce to close.
And I'm not listening to him.
Given the nature of this and
Images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
all right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
6 minutes. You're on the clock, boy. Unbelievable. Crybaby bullshit. I just don't even feel like we're watching it. It's just so hard. It's so hard to watch this because I feel like we're not watching anything. I mean, geez. Everybody just wants to cry and complain. Complain. That's all I've heard from all the cases I'm covering right now. All it is nothing but complaining. Yeah. Yeah. Unreal. The exhibit should have been public anyway. So how about that? Think about that. The exhibit, and that's what he needs to say, is out of abundance of caution, I've made it like to not view it. And it's something that I'm going to be taking in anyways. It's admissible. And so therefore there's nothing to do about it, because what are you going to do? Give me a break. These people are wild. Babies. Murky says, oh my God, here we go again. A recess after doing nothing. Absolutely nothing. And to think that this is what our money goes to, our tax dollars go to this shit. For lawyers to get paid hundreds of thousands of dollars, so much money per hour to do this, to cry. We're paying lawyers to cry. Babies. Fucking babies. This isn't about rights. I mean, you don't need to write a fucking motion, brief. Here you go. Here's your brief. It's pretty well outlined in my brief, Your Honor. I don't need to stand up here and hear myself talk because I like it. It's ridiculous. And it should be, all this should have been handled. You know what? You guys have this issues. We're going to get here at 8. Because we're going into the courtroom live to go, at 9. This is not using valuable resources of the court's time.
thank you, by the way, as an aside, to the many of you who have filled my inbox
Listen,
with the search warrants you have collected. I appreciate that so much. I will be going through and collecting those and maybe compiling them in a separate
careful.
format, a separate place, you know, like on the Substack or whatever, so that we can have those available too. So yeah, the only thing we saw about this note that we didn't previously know is what condition it was in when Lance took the photo of it. And so that's the juxtaposition. That's the juxtaposition. And so I guess that's the prejudice. You know, it's
was the
it
note
lies-
folded? Was the note even folded? Because if it's underneath the keyboard, like, are there crevices? Are there creases? Is this note folded? There better be. Was it in an envelope? How can it just be under your keyboard? Look under my keyboard. Stop what you're doing right now and go run to my keyboard. I said an auto text. You know that Lance could have got his phone and sent that auto text? You know, because you send it, you create it earlier, you create it in the middle of the night while Tyler was sleeping. The note is burned and gone. All we have is a photo. I want to know what lighter burned it. These two don't look like smokers. Lance doesn't look like a fairy, doesn't look like a furry, doesn't look like a gay man. He looks like he looks potentially like the guy from Clemson that played football, a quarterback. He's a mix between him and a frat boy. And his voice is so deep. He has a really deep voice. A lot of gay guys do not talk like that, okay? They just don't. Sorry. Especially not ones that want to become females. But whatever. And my gaydar is pretty accurate. That dude does not give me any gay vibes. I would never try to hook him up with one of my gay friends because I would never think he was gay. I would have to say, prove it. At the bar, prove it. Come on. I know you videotaped yourself. Let's see it. Man, it's Friday, guys. Anything goes here. Let's get the cowbell going. Lana, I needed your gaydar for case. Send me a pic. I'll give you pics and voices. Put those together and let me go. Let me go ham. He gives off killer vibes. He just gives off I don't know what the fuck's going on vibe. Like Tina. Oh my god, Lady Di, I thought you were pissing, like literally pissing. Whoops. What do we got here? Lady Di, member for 24 months. Love it. Member for 18 months. That was beautiful, Lana. Bunny. Thanks, Bunny. Bad Bunny in the house. Meow. I can't make out this Lance guy never called 911 when he found out. It's all those sketch. No, he just decided to go to the police department and just, I don't even know what. He was getting raided by the feds. Well, I do pee a lot. Tina knows what's going on. I know Tina. Tina makes everything better, guys. And if you disagree, I'm going to get a Tina shirt for you. This is Tina with What the Fuck Translation Services. Judge Gaff, what the fuck you talking about? Entertaining this shit. You guys need to see my funeral potato shirt with Jose Baez and Diane Menashe on the front. And then I made another one that has Diane Menashe and says, "We don't need no Stifler. We don't need a stiffy." The prosecutor's name is Stifler. So who needs a Stifler when we have a dirty Diana? look out. Can you imagine me walking in the courtroom with those fucking shirts on? I'm fucking dead. Funeral potatoes. They'd be like, girl, you can't wear that shit in here. Why? What is going on with this? Look at what we're looking at. We're checking someone to see if they have lice and shit. I'm gonna get all the bailiffs all. My name is Lance. Lance. Better than a fan. I told him that he might, yeah. I mean, be careful with those bullets. You might just blow off your hand. Oh, God. DB, what do we have here? Let me take a look. Okay.
When I got there, the food was on the stove. It's kind of packaged. The canvases were kind of off to the side. The island was pretty clear. I didn't, and Jade had a glass of like a pink drink, and Blaze wasn't drinking anything. There was no cup in front of Blaze.
And did you drink anything while you were there?
I didn't drown.
Was that something you brought with you?
I did not.
What was Mr. Taylor doing, and where was he at in the room?
He was sitting, approximately, except Blaze what he was gonna think.
You're asking me if I think that this black chick's gay? Is that the question? Is it the girl? I mean, I wouldn't say she's gay for the stay, but I bet you she'd go both ways. If that, okay, yeah, I totally would go both ways. I mean, I think she likes both. That's my final answer. She's not gay for the stay, but she'd get down. I would like to see some photos of her just out and about. Can you get those to me? Perfect. Thank you. I will send that to the appeals team. Why? I don't know the case. Is it important if she's gay or not? Hotornot.com, gayornot.com. Yeah, I'm going to need some photos of her just as is, if you have any. I just need an affidavit from me. My gaydar does not go gay for her, but I definitely put her in she'd play ball. She may even hide it. That's my assessment. We're already, what is it, 9:50? I mean, what's this guy doing? What's going on? He is 6 minutes past the deadline. She was an alternate suspect? Well, she was an alternate suspect, and she seemed to have a much closer relationship to the victim than she let on. She was mad that the victim and Blaze ended up getting back together. Was she mad at the girl, or was she mad at the guy? I'm interested. I would like to hear more about that. Them fucking jealous bitches out there. JLR just said it's been longer than 5 minutes. JLR, man. Did you see those text messages? Oh my God. What a toxic relationship. Holy ballsack. I feel bad for both of them. Like both of them. Just toxicity. Magnolia, you are ruining everything. We are almost to financial freedom. God damn it. Then you want to pull this shit. Oh, I don't even know what that means. Financial freedom. Like, what do you mean? We are almost to financial freedom. I would hope to God, because you're making so much money, like sick money, like stupid money. JLR is making stupid money right now. And I mean, I love it for him. I don't love seeing the toxicity though. You know, it's sad. Former Titans scout. She was a football scout? She's totally bisexual. You didn't tell me all that. Fuck. She's a football scout? Mm-hmm. She's got control. She likes power trips. Oh yeah. She's scouting at them cheerleaders. Such a beautiful light we are looking at. Those lawsuits he was filing in prison were insane. I know, right? She's a dental assistant now. What a fucking drop off. That's gotta bother her. She's, you know why? She's trying to fit in. I don't agree with JLR used to do, and he still does have his quirks, but I think he's tried to turn his life around. I know. I think I honestly, like, well, when you aren't taking your medication and you're supposed to be taking medication, I mean, that will really fuck you up. But some people just are not good together because they push your buttons. They know how to push your buttons, and those just aren't people you need to be with. You know, you need to complement each other in life, especially when you get in relationships when you're older. It's like, come on, they don't have any kids. Like, I don't got time for all this shit. Get the fuck out of here, man. No one's got time for that. I don't need no jealous, fucking crazy. Like, you know, compliment it or you complicate it. It's just one or the other. There is no middle ground for me. You either make my life better or you cause static or you cause toxicity. That's it. I don't need no static either. Oh, I know Blaze was a scout. Didn't know the friend was. Yeah, oh, Blaze was the scout. Okay, DB, you better get with the times here. Don't be sending me false information. DB's not blowing me up. He's like, take all these photos. What do you think? Okay. Okay, girl. She's feeling herself. I mean, so are you saying that she could have potentially killed a male? Is that what we're going with? Blaze was the quarterback on the Minnesota Yankees. And he's dead now? I mean, what is going on? Do you guys see that nothing gets done in this damn Utah courtroom? They didn't move this out of Utah. Fuck changing cities. Just get it out of the damn state. Funeral potatoes and wedding gravy. Ah, those are great. What are you guys having for lunch? Let's already talk about it. It's noon. Late to the party, Carson. You are, but we're about to get down. We're talking about JLR. Welcome to Star Mix 106, where we chop it up your way like Burger King. We don't care how many contributors you got. We will make it whatever we want. So Lady Di's having soup. How hot is it over there? Jimmy John's. You know what? I'm feeling Jimmy John's now too. I am so mad at Tony for taking so long because of that, Tony, 30 people left. 30 people left. They weren't having it. Who would be having it? Like I got way better shit to do. Like who the fuck wants to do this shit? Scared of stealing. Oh my God, it's true. Adam Deitch did run the federal grand jury. Yes, I knew it. I was waiting for the docs. They just said that Josh Levy did. I knew he just didn't do it. I knew it. Ooh, I think do we think that Adam Deitch is gay? Because I think that Adam Deitch and Alan Jackson might have a thing going on, and I think Karen Reed is getting jealous. So there's that. If you guys want me to spill some tea about how I feel about my gaydar, you know, but I think Adam Deitch might be gay. And I think it's causing potentially Alan Jackson to start feeling himself another way. But hey, who's having clam chowder? Chowder? Okay, we got some movement here. This poor girl that's running the camera, she has to get up every day in front. Jackson is gay. I don't know. I think he would be gay for Adam Deitch. I think Adam Deitch is, but not Alan Jackson. He was a Texan Republican married to a young hot prosecutor, and yeah, that's his life a long time ago. Steak, cut, calamari, and lobster bisque. Oh, that's nice. Are you at the country club? Crab chowder. I'm dying, Alana. I just want to marry Kenny Chesney. He never tells me he's gay. Maybe. I mean, who isn't? Everyone's bisexual for somebody. Let's be honest. Ask yourself the question, what guy or girl would you allow a hall pass? You know, ask yourself. Just be real. Just be real with it. You know? Like, I love Paul Walker. I was so crushed when he died. I thought that we could potentially get married. And then he fucking died on me because he's had to race those damn cars like a fucking idiot. I told him to knock that shit off. I said, do you want that whipped cream bikini? I said, I will suffocate you in my titties. What you want, boy? Poor Paul Walker. My dad used to tell me that Ricky Martin was gay. He's totally gay. And I would yell, no, he was always right. Ricky Martin is totally gay. You think Enrique Iglesias is gay? Because no, I mean, isn't he married to that tennis player? So let's all talk about our peeps. That we, you know, I have several girl crushes. Oh my God. See, Carson, she's like, I'll tell you. Okay. I'm a golden star straight, never ever. Sheila cracks me up. She's like, listen, this is how it is. I understand, Sheila. There are some golden stars out there, I guess. It's okay, Sheila. You can be a trisexual. You'll try anything once, right? Halle Berry. There you go. Halle Berry, Monsters. The Monsters Ball, right? Anna Kournikova, that's it. Man, I'm with you. I never believed Ricky was. Ricky Martin is totally gay. Isn't he married to a man? Lance Twiggs is going to have any man he wants after this trial. Lana. Just hopped on. Love the soccer analogy, Lana. Yeah, VAR. We've been chanting it. They're in the replay booth right now. Okay, we have no idea what's going on, but Judge Gav getting some calls from upstairs. I'm sure Trump's on the line, making it known. I know you ain't cutting off my soap opera. Okay, this is the new This is going to be the new O.J. Simpson case, 9-month trial and shit. Oh, wow. X is a war zone. It's ground zero. Yeah, X is full max. Anything. Everyone's just blasting each other. 50 Cent, gay or straight? Drake, gay or straight? Let's see. Ooh, how about here's a good one for you guys. Sophia Bush, One Tree Hill, Brooke. She just was like, you know what? Ashlyn Harris, divorce your wife. Let's go, girl. Yeah, there you go. There's your hall pass. I bet you Dylan Mortenson's right there with you talking about Criminal Minds. Sherman Moore. Diddy making everybody try it with him. And then he would blackmail you. That's how he got you. Eleanor Roosevelt was gay. Thought I would sling that in. Hell yeah. Hell yeah. Lance Twiggs. Dude. Luna. It's a gaming name. You sickos. Where you know is my hall pass? I dead. Yeah. I think he golfs a lot. Go be a golf cart girl. Man, last night Atlanta live replay was nuts, wasn't it? Just wild, mind blown. Idaho lives in their fucking delusions over there. Will Smith is someone's hall pass? Or are you saying he's gay? Because I would never use my hall pass on Will Smith. 50 Cent has still got it going on for his age, and I saw him last year perform, or maybe 2 years ago. Oh, good. Usher was just in Cleveland. Usher, baby. Post Malone was just in Columbus. I was gay a few years ago. Thank you for sharing that with us. Cheers, VAR. Should we get that on replay? VAR. What is going on? What's going on? This was supposed to be a 5-minute break for him to, I don't know. Does someone want to go check on the judge? Make sure he can give him some water? Eleanor was definitely gay. FDR was hooking up with his assistant for many years. You think Marilyn Monroe's got on chicks? Speaking of which, she was totally murdered. They're filming right now Landman. I think, what is it, season 3 or 4? Can't wait for that puppy to hit. Brando and Pryor, what's that? Who, huh? Lana, according to JLR, this has been longer than 5 minutes. Yes, JLR. Okay, I'm going to have to order Jimmy John's. More of Reed's mess. If you look at the docket, you'll see Karen Reed's 12B6 special motion to dismiss has been docketed, but it's not available for viewing. I have no knowledge of why, but my assumption is it has to do with the email reply the judge was waiting for. Okay. Defense diary says, look, plain and simple, the ball was dropped by Karen Reed's legal team with this motion to dismiss. Based on the reputations of this collective of attorneys, it's rather inexplicable.
The court is back in session, noting the presence of counsel in all parties, and where we left off is the court took a recess to
take a shit.
Review the video. And I appreciate the patience of the parties as well as everyone in attendance when it comes to constitutional matters and balancing constitutional rights and transparency. This court will take the necessary time to make sure it's given the weight it deserves, and it is deserving of every moment that has been spent. Mr. Novak, turning to you. And perhaps before you begin, let me go ahead and make a record of what I noted that is at issue. And after I put this on the record, certainly if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera. Exhibit 16 was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected.
The VAR is in, you guys. VAR. 3.1 seconds. Here is the ruling.
Was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected the camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded, "Let's take that down." The full text of Exhibit 16 had previously been made public through a search warrant that was publicly available on or before April 2026. The portion displayed on the monitors did not contain the full note and consisted of approximately 78 words.
Yes, what I tell you guys. Woo! I said it wasn't in full, you fuckers. Woo! VAR. I mean, this is as VAR as you guys can get. Welcome to the World Cup in Utah. Yes, this is Mormon style, guys. Welcome. Hit the thumbs up, hit the thumbs down. This is the VAR.
Only 15 of those words were included in the information filed on September 16th, 2026. In addition, the full note was read into the record during the preliminary hearing. The court previously ordered that Exhibit 16 be admitted into evidence and permitted its display within the courtroom, but prohibited its publication through the camera used for the live stream. And that concludes the findings of the court as it relates to this issue. Do the parties wish to be heard before we go into what you're requesting about the record on what occurred?
Your Honor, your recitation is accurate. My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that the court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough.
Sure.
If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an
Audio.
alternative, and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say preliminarily granted the request for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be, just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests. There were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday. The fact that the content of the exhibit
Why would we be
was
punished?
previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. That's the fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here, and of course the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying motion 305 and grant it for the balance of all of the proceedings in this matter, or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Thank
Thank
you,
you.
Mr. Novak.
Thank you very much.
Turning to the state and then to the media.
Yes, Your Honor, as to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to order the media to look into that capability, and that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist. And I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published. I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't, every moment of every hearing deliver the result that we are intending to deliver. Those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after a long briefing on all of this, the court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that. We'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you. Any further arguments before the court issues its ruling?
No, but thank you for the opportunity.
Thank you. And just updating my notes as I'm intending to issue this ruling right now. I'm just making sure that I'm capturing all the points made in the argument right now.
Though, you guys, that was a hot mic by Mr. Novak. Did you guys hear that? Oh my fucking God. Mr. Novak's hot mic right there. Clear Eyes. Let's do a Clear Eyes commercial.
For dry, red eyes, Clear Eyes is awesome. Unlike the other leading eye drop, it removes redness and has an ingredient to moisturize. Wow, the difference is clear. Clear Eyes.
Woohoo! VAR.
Observe dry eyes, red eyes, symptoms for which science created Clear Eyes. Unlike the other leading eye drop, Clear Eyes removes redness and has an ingredient to moisturize. The difference is clear. Clear Eyes.
Thank you. Just can't handle it. This is the 1997 commercial. Ben Stein.
When eyes are red and dry, use Clear Eyes. Unlike the other leading eye drop, Clear Eyes removes redness and has an ingredient to moisturize. Now there's a Clear Eyes for contact lens relief too.
Oh, thank you. Appreciate that.
Or whichever one of them.
Oh, there we go. Hope you guys appreciated that. VAR. We have VAR going on right now. We're just waiting for the ruling. VAR rulings coming out now. VAR ruling on the partially exposed exhibit. The handwritten letter. Judge G has a ruling on the field. Okay. VAR. And the crowd silences. You can hear a pin drop in here.
I'm almost done. I appreciate the party's patience. This issue rises to the level that necessitates great care. And as my practice, I don't like to rush or
We-
make snap decisions.
we see that.
I want to give this the full analysis that it's due. So thank you again for your patience.
After review, the ruling on the field stands. After review, the camera woman did make incidental contact with Exhibit 16. We can look at her face and see that there were tears in her eyes when she did that.
The court will issue its ruling on the request by defense. The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense. This constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st.
All right, yay! VAR comes back, and the defense is basically denied because we're going to hear everything and see everything today because nothing is really going up on the monitor anymore because all the exhibits have already been shown. Woo! VAR. The ruling on the field stands. Cheers. Play ball.
Hearing and address it at that time. This is the ruling of the court. Thank you. Turning to the defense, if you wish, you may call your next witness.
There we go.
We would like the benefit of the record before we start taking evidence today.
Yes, Mr. Gernander, and I'll allow all parties, given the ruling of the court, briefly.
And I'll be brief. And this is in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt, the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases to include State v. Schmidt. Schmidt continues, this means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial. A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, the standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense. So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, the magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial. Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing if it is, quote, so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence. There's a State v. Drozbecki case, which is a Utah Court of Appeals case 2010. Magistrates may only disregard or discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this probable cause standard at a preliminary hearing, the court said, under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution, close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Grunander. Do other parties wish to be heard as it relates to Mr. Grunander's statement? To the defense?
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Miss Oliver and the other experts and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports, which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon, direct and cross, and that will be the end of it.
All right, thank you, Mr. Burton. And before I have you call the witness, just want to make sure that the media had I'm not sure if the media needs to be heard on Mr. Grunander's response. All right, thank you. All right, Mr. Burt, you may call your next witness.
Thank you. Call Miss Oliver.
Okay, here we go.
Ms. Oliver, if you'd like to come forward and be sworn in.
Our last witness.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, ma'am, you may be seated. And there's a water bottle to your left if you wish.
Hydrate.
And after you're seated, if you wouldn't mind adjusting that microphone, bringing it close to you to pick up your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Miss Oliver, could you bring that mic a little bit closer? So I want to make sure your voice is projected. Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence?
So we don't get to hear any audio or testimony from the, look what's going on here. Which was ridiculous. Unbelievable. no idea why there's no audio. Like, what in the hell is going on? I don't even know if this is supposed to be like this. You guys, what are we talking about here? What's going on? Does he even realize what's happening? Can somebody tell Tony what's going on? Tony the Tiger. Rawr. Andrea doesn't have volume.
Based on
Going to be captured by the camera and,
Okay.
and displayed.
We were 35 seconds behind.
Any exhibits displayed. Is that your understanding?
that is my understanding of the court's ruling, yes.
Little Miss Girl, you're a dog in heat right now. Everybody's hot to you.
Well, that's why I give my notation beginning of the morning that the parties are responsible to monitor their monitors. And that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur. And that's why that instruction is given.
Fucking idiots.
I don't understand what you're saying.
It's not being published on this one.
Right, the order of the court based as a sanction is no exhibits will be displayed. As it stands right now, yes, that's correct. Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you, I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing. And the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you, I appreciate your concerns. Mr. Burke.
Could you redisplay exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5.
This is the ATF DNA report of the
Use
rifle.
the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that, from the FBI, testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
Does your agency employ that scale?
We can come to 5 conclusions at our agency. So there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report? And highlight the very top of the first 2 sentences. You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
Standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examine, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right, and would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty.
Correct.
Correct. Now, when you can take that down, when did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay, let me pull up Oliver 3 for the witness only. And go to the third page. Does that third page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination.
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your policy have, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right, and they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against the possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay, could you now go back to Exhibit 30? Page 8. Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay, then are there a number of samples listed above there in the report where you say the DNA extracts will be retained? And then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1.
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
Right. Does that mean, does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
I refer to my tables in my report.
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
With the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures, such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language you use in your report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only? Are you familiar with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Correct.
This is put together as a guidance document for practitioners on what, to simplify it, essentially what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? This is Baker 30. Keep going. There we go, right there. Wait, 135, I'm sorry. And then scroll down to the next page. So they're making recommendations here as to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap? And they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I
Okay.
agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation they talk about on likelihood ratios on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded. So there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next limitation they suggest you convey is that convey the DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't mischaracterize it. Your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes. Once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped?
So it's possible if, say, the pen that you're sitting there using for the week, you say, hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands. I then went to pick up an exhibit, a gun. I touched the trigger of it. Your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults. So things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to say swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive, and so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twigs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay. And if you could scroll down to page 4, which is the table. I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there's support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And there
Again,
would-
not because he's a suspect, but because he's associated with that premise.
Correct, and there would have been a likelihood ratio statistic calculated and to go along with that.
Okay, could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swap number 1.6, or a profile that indicated he was a possible contributor.
There's support for inclusion of Matthew Robinson.
Okay. And next page, actually go to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA. So it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
All my New
Have they
Zealand
developed
friends.
Another program called STR Mix NGS?
Star Mix.
I'm not aware of NGS software.
106.
You go to 156, Oliver 156.
Oh my God.
Let me know when you're there. Are you aware that STR, the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals. And there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those.
Yes, this is Welcome to Star Mix 106. DJ here, Sugar Tits, throwing down the ones and twos.
Lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only?
For the witness. One time for the witness.
You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like,
No, you were right, 154.
They had their own freaking apartment, a condo, whatever they want to call it.
Yeah, this is one. What's the exhibit on this?
Oh, I got my own little recipe.
Okay. You're familiar with this chart, right?
I reviewed the first page of this chart. I have
Sure.
not reviewed the entire.
Go to the
That's called
first
Sugar
page.
Tits.
This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence had a 17 allele
Correct.
at that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison. So it's not just number matching. We're using STRmix, the StarMix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 1717 and the evidence sample is a 1717, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found that that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection, relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunander's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed and we'll go from there.
Okay.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that,
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection. And the question may be re-asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends.
Again, objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt?
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. A likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors?
Yes.
You assume?
No, it does not.
What?
It has no effect whatsoever.
It can have an effect. It's possible. It's possible.
Fuck outta here. These
multiple
people-
other factors to contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report, you used the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say, the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in
The
sorting out
difficulty
that mixture
happens.
increase as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me,
Okay, all the reason I went fucking ape shit is because I just have to hear he has to lay foundation. So much of this is foundational questions, which means that I have to ask you so many questions so that we can get to the fact of the matter that you can answer what I'm about to truly ask you. Okay. And that truly question right there was about this, how many contributors were on these objects. Okay. And isn't it difficult then when the more contributors you have that to separate and do all this shit? And the answer is fucking yes, it is. Okay. I learned this when I went to California and doing stuff with Gabriel Vargas. Okay. It's like for this girl to stay on the stand at first that no, and then he had to walk her through it to the right there. She just said yes. It's difficult. It's more difficult when you have more contributors. I mean, these people will just lie unless you hold them to the fire. And it's disgusting because now we have lab people lying. But think about it. Ever since DNA has had to take over, you got to go to those people to get them to lie because it's not just the investigation, the investigators anymore. Now we need these motherfuckers to lie. So it's just disgusting. It's all disgusting. Everybody can just sit and spin. Woo! VAR baby. I'll rewind it back here. Look at her. Look at this frumpy. Okay. It's a Friday and this is how she looks. Okay. Be happy. You're alive. If this broad's gonna look like this in front of a jury, like God, whoever becomes the jury people on this case, we need to start a GoFundMe for them because they're gonna need a vacation after this shit.
if I'm wrong,
Here it goes.
familiar with that, right?
Yes.
To a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures.
Last night.
Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
Correct.
It's possible for them to present. Yes.
Yes.
Well, it doesn't say it's possible. It says, for example, approximately.
I love it. He's like, it doesn't say it's possible. This is what your fucking manual says, dumb hoe. She looks defeated because of last night. Couldn't get an answer. And now you show up with this frumpy face. And we all have to deal with your fucking frumpy ass.
In all cases, assuming a mixture is a result of the combination of 3 people must be done with caution. For example,
I'm done with these.
approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
You said you're referencing my SOP.
Yes,
Is it possible for me to take a look at it?
sure.
Absolutely. Would you like it
I'm
in front
gonna
of you?
object At this point, the
Oh.
point that defense counsel is getting at is made in the last answer, which is the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood. But that
No, it wasn't. Not by this hoe. She fucking at first said no that it didn't, you cocksucking motherfucker. Sit down, McBride. Sit down. I ain't playing. I'm not going to let this shit go on. He is misrepresenting what the fuck just took place for the past 10 minutes. And how, do you understand? Like, think about it as like a kid growing up. Your parents are watching you, right? And you're going to try to lie to your parents about what you just did while they watched you. It's one thing if they didn't watch you and, oh, I didn't do that. I didn't open that. I didn't. Motherfucker, the judge is sitting right here and you're trying to rewrite history. And all of these lawyers are doing it. And I'm just like, the fucking balls on these motherfuckers. But these pussy ass judges just like, I think they snooze out. To be human. I mean, listen to this boring shit. So you could probably get one past him, even though he's supposed to be here present.
has nothing to do with probable cause determination. Even if it's
Fuck you.
difficult,
Yes, it does.
the inferences and the evidence is weighed.
Because we're talking about the reliability and how the fucking material got, how his DNA even wound up on that. How? Because you guys didn't put together shit. You want a guy, 4 dudes, 3 dudes, and multiple cars to be all one fucking happy-go-lucky person in a car, and it's just not.
For the state, the court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying there's going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may
Well, of course you will. Of course you will. Because they've been leading the whole goddamn preliminary hearing. I mean, why are they not objecting to all these leading questions is beyond me.
material and
No one's going to lead anybody if I was sitting opposite of them. Nope. You want that person to stand? They're going to say everything, not you leading them.
So could you bring up
question can be rephrased.
one, exhibit Oliver 148?
Oliver 148 means her name's Oliver, last name probably.
This is your SOP document, correct?
Correct.
And it's the exhibit that they're labeling whoever the last name of their witness got. That's why it's Oliver 148. That is not a normal way to reference exhibits for the record. They're usually the state is numbers and the defense is letters. Okay.
Page 83.
Where's Big Booty Judy?
That correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
It's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit.
Yeah, we have. Just like last night, right, Judge? We were going for a little long bit, weren't we?
And depending on how much
We were listening to that Star Mix 106 though with your girl Sugar Tits.
to cross, and trying to decide if a break is warranted or if Mr. McBride, you wish.
I mean, do you guys just take breaks like all day, every day? I mean, just everybody that's a smoker out there, go get a job with the government because you get breaks left and right.
Your cross is limited. Again, not trying to say which way you should go. I'm just trying to weigh whether we should take a break.
I will probably be, I'll probably be 20 minutes.
Then we're gonna.
Let's just keep going, and then at that
Yeah,
point,
Daddy, let's
we
keep
can
going.
Take a break.
Show me your 20-minute.
Mr. McBride.
Here we go. Cross-examination. Thank God. I love Big Booty Judy's. Bring in Judy, Judge Judy in this motherfucker. for the record, if I am covering this trial, we will be doing bingo. There ain't no way I'm doing this trial without bingo. Okay. Which means all of you guys have a chance to win $5 to $25 every bingo. And we play multiple games a day with the trial. Truth and Transparency donates the money. But I think I want to have like a big grand prize if I'm going to do this trial, like a cruise at the end with Lana. And we're going to bring the jurors with us. But if you guys are new to Truth and Transparency, I work my ass off with the documents. I do a ton of research. That's what I'm known for. My criminal research is timelines. I can catch things put dots together like nobody's business. We go seek stuff out where people don't think to. We get creative with it so that we can get the documents. And when I'm joking around with my presentations with this, it is by no means a knock to the victims, their families, the suspect, the defendant here. It is simply, that is life. And you're going to do serious things while you can flow. You know, that's just how I am. Yeah, let's go. I'm an athlete, Division I college 2 sport athlete. And I don't got time for this frumpy ass shit. Like VAR, I'm here. Here she goes, Frumster on the cross. Give a shout out to all my mods. They make chat fun as fuck. Thank you for that. We have
Good morning.
fun.
Morning.
We raw
Is your
dog it.
lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO.
Nobody cares about this.
Yes.
Moving to your opinions. Where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
Good question.
There were several locations. I'd have to refer to my report.
Okay, would you
Ooh.
look at your report? And this is, it looks like report number, or exhibit number 30. We can pull that up just for the witness.
And for the record, if Turtle Boy gets convicted, I'm going to help him in his appellate process.
Had it for a minute here. Let it go.
Because every defendant deserves the best criminal researcher.
Okay, if we could go to page number 2, please.
Who is speaking? I just got here.
Just list off the areas of that firearm
State.
where.
Remember, this is cross-examination. This is the defense's witness. So the defense did the direct, and they ended her direct examination. And now the state is crossing her. This is an FBI or ATF DNA analyst.
There was support for evidentiary support for inclusion of Tyler Robinson.
Her name is Olivia Frumps.
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle,
Butt.
swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging,
Creeper.
the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question, in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
Do you know what
said at
those
least
likely
1 trillion
ratios are
times
like?
more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there, the trillion number, it could be far less than that, but you stop your calculations of the statistics at 1 trillion, is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly. And 2.1 is the swabs of 1.30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired. Cartridge case has been fired.
Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of 2 individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together. Is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about the a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Burt.
The 1.3 sample, is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct. So they were swabbed together.
Oh
So
my
that's,
God.
Where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors, right?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison.
Why didn't
and
you
the
get any
minor
of his
contributor
family's
is not
DNA?
Suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing, has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30.
Wait till you guys see my coverage of the Sharilla case with the transcripts. She deserves a new trial.
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called the random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person. Can't state it's infallible. Can't state there's a 0 error rate. And you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
Come on.
All right. May this witness be excused.
Of course.
All right. Thank you, ma'am. May I step down?
The defense calls Tyler Robinson to the
Further
stand.
from defense. All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present this state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1, so that the victim's family can observe that.
Oh,
Thank you.
just give them a copy.
All right, do the parties wish to be heard as it relates to this?
You guys.
Briefly, and then the court will issue its ruling.
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
Is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser.
Oh, you let us show him?
In regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Jeff and I, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know.
Thank you.
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you.
Well, duh.
All right. Nothing further from any of the parties? Okay. Just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the state. So could the camera operator let me know when we're switched to an audio only? We are? Okay.
Wait, we're going to play the audio?
All right. And as it's switched to audio only, to the state, now my understanding there's no audio on this surveillance on 12.1. Is that correct?
What?
All right. So let's go ahead and play that.
Wait a second.
And I'm going to rule that this also applies to the still photographer. It cannot be captured the screen in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right. And,
Okay.
To the state, just let me know if you're ready. Let's go ahead and
I'll tell you what's happening. There's no audio of this. We can't see it. 12 is the UVU surveillance from 9/10/2025. The doorbell camera surveillance. So this doing 12. So is this the? I thought they went ahead and played it for us though. I don't know what they're doing. It makes no. Okay. Well, this is stupid. Well, this is happening. 12.1 blows. Doesn't matter. It's stupid. There's no audio with it, so I don't know what they're talking about. But let's go to very interesting. What they did not show us here today in this preliminary hearing. Okay. What was expected in the Idaho 4 preliminary hearing before it got to your grand jury was FBI cast draft reports, showing the location from the phone of Brian Colbert. So we have to ask ourselves here in this case, right? The FBI was involved immediately. We know that there was Cellbrite done on devices, and we know that a ton of geofence locations would have been set up. Cell tower dumps, okay. And then we know the device of Tyler Robinson, and if it was on, and if it was utilizing locations, then depending on his carrier, we're talking like significant possible GPS of Tyler Robinson. We heard them testify in this hearing that the reason that they went and even looked at footage close to like 9/11 becoming 12:30ish is because of when they went back, because of basically cell phone data. But in this hearing, okay, in this probable cause hearing, we heard nothing about digital evidence. Nothing. Just, I mean, you're allowed to testify to hearsay. You're allowed to testify, meaning that like if somebody provided you with information that's a reliable cop, FBI person, you could testify to that in this probable cause hearing. They didn't use it. And great point, simple me too. Neither side. And I think more so from the reason that the defense wouldn't, I don't think they're going to be saying that he wasn't there, but we'll see. We should be asking ourselves why.
All right, and that concludes the playing of Stacy Exhibit 12.1 video. Transmission may resume. Just let me know when that is live. When that is live.
Are you trying to say that you didn't realize that we were live? We just couldn't hear anything? Okay. Aren't you just breaking to go to lunch?
Does either party need the benefit of the record?
No.
State does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism.
Okay, for him not to rule at the bench right now.
Persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
For his ruling. Okay, so I want to show you guys something since you're here, right? I'm going to use Hector. The cat's out the bag. I'm in possession of Tom Slavinsky and Cyray's reports. The reason that Cyray got involved in this case, okay, because of Tom Slavinsky. Cyree was going to be anticipated his testimony to focus on interpretation of drive test data and mapping supplied by the state, analysis of call detail records, geolocation data review and analysis, and opinions regarding the FBI draft cash report and final cash report. Okay. And why I think it's imperative for you guys to see this that are watching the Tyler Robinson shit. I'm going to have my own live on this just by itself, but I want to show you something because it should blow all of your minds at what the FBI is capable of doing. I want to bring in Hector the projector. Hector the projector. Okay, it is imperative to understand that that this response serves to supplement the information in the report attached as Exhibit D11B, photographs and or video drive test data and related reports or past testimony as previously discovered to the state on January 9th, 2025. So I need everybody to understand that Cyree wrote a scathing affidavit in connection with the Idaho 4 case against basically the prosecutors, the FBI team, and pretty much the judge. And so it's to understand this, that comes after this report and the previous report that he wrote. So you have to understand this is so, so important because the timing of this is the prosecutors had this and so would the judge because it got filed with the court. Even though it was under seal from us, that doesn't prevent the judge from seeing it. And this is what he was focused on to do for the defense. This case never went to trial. Now, in the beginning of his report, it states why he got connected into this case. And so one of the things I was going to present was Cyree explaining this to you, but here his report does a great job of saying is like, I was contacted by Tom Slavinsky of Cellular Forensics in reference to a technical question. Tom Slavinsky is a forensic guy. He has his own company. Ann Taylor hired him in October of 2023. Tom was a client of basically Cyree's product that he produced to do all the mapping and everything, which you're going to see when we get into, right? Where is this crap? So this is Tom Slavinsky. Anne reaches out to him first. Then what you do in situations is you will hit up when you come across something in the field that's like, oh my God, I got to go to like someone that's a guru. You got to check this out. Okay. Yes, but love you, but I will only be here. Yes. Yes. Once the game starts. Yes. Now check this out. So, Tom hits him up and says, hey, because Mr. Flinsky has a company and he was a subject matter expert. Like I told you, he did a course all under. So Cyree already knew who Tom was. And it was right here that he says, Mr. Slavinsky did not provide any case information because it was all under a gag. Okay, there was a non-dissemination order issued by the court on this particular case, and he could not discuss case details. His question pertained to drive test data collected by the FBI CAS team. Mr. Slavinsky voiced some concerns as to the accuracy of the data. Now, drive test data, you guys, you go out, you have this, you basically get in a car and you fucking drive. And so for someone to have a concern about this, it should blow everybody's mind because it's how? Why? What do you think happened here? Are we talking about like manipulation? So in this case, they would have done this with Tyler Robinson. You would take drive tests all over that area because you're going to have all the coverage mapping and you want to be able to, in the Tyler Robinson case, outlay him and his movements and describe that to the jury. So what the feds did in this case, they would have done in the Tyler Robinson case. Now, so basically he had to get approval. Hey, go ask Ann Taylor, if you guys want to bring me in. And so then Cyray comes in on October 27th and he signed his confidentiality. Okay. Now, the evidence I reviewed was mainly in reference to call detail records. Call detail records are what you get from Verizon, AT&T. You get it from the carrier. And when you get those call detail records, from those call detail records, you can do a lot of mapping and moving of someone's phone. So, but a really big tool is the timing advance records. We'll get into that. So his purpose is to review the call detail records, the mobile device forensic extracts, mobile device geolocation data, police reports, drive tests, and FBI CAS report, timelines, surveillance video, and financial records. One of the first areas I was asked to address was to review and assist in the interpretation of the drive test data. I focused on the available drive test data collected by the FBI. Initially, the only data I had access to from the FBI drive test was contained in the FBI CAS draft report and what was briefly mentioned in Special Agent Nicholas Balance's PowerPoint report. The draft report is dated July 10th of 2023. Cyray testified in a hearing in May of 2024. Special Agent Balance's report, PowerPoint, was the only summary of the drive test and is dated 2/15 of 2023. They arrested Brian Kober in December of 2022. The report's drive test states data was collected between November 16th and January 6th of 2023. The report states the data was collected by both Special Agent Balance and Special Agent Kennedy. The areas focused on are vague, described only as Moscow, Pullman, and south of those towns. The report does state the raw files were enclosed in Special Agent Nick Balance's original report. The raw files are critical for any analysis. I learned the raw files had not been disclosed by the state and requested the files to be obtained for further review. In reviewing Mr. Kohlberger's AT&T cell call detail records and the FBI CAS draft report, so think about like Tyler Robinson, I immediately became concerned as to the accuracy of the drive test mapping, specifically the shaded areas representing coverage found on slides 112, 116, and 120. They fucking made up coverage areas. Watch how they fucking did this. This is unreal. In comparing commonly seen handoff data in Mr. Kohlberger's AT&T records, the coverage areas depicted the FBI CAS draft reports are severely flawed. Further analysis would require access to the raw drive test data. In further review of the draft report, I also noted several other areas of concern. The mapping of tower connections provided in the draft report was missing significant data from the AT&T call detail records. On average, more than 90% of the available data was not mapped during the time periods represented in the report. This is not best practice and creates a number of issues as to the accuracy of both the analysis and related report. Now, my main concern at this point of my analysis was the appearance that the missing flawed data was exculpatory in nature to Mr. Kohlberger. Given the complexity of the subject matter, I explained that for me to provide an expert opinion on this matter, it would take a significant amount of time. I would need to have access to more data and would also need to conduct a drive test. I was asked to work as an expert on the case and conducted a full analysis of the available data. The following report was, this is what he had. So section 1 of this report, so due to the complexity and analysis and the volume, here we go. So section 1 is inventory of the data that he took in. Section 2 is methodology for review and analysis of the data. 3 was the drive test data review. Then 4 was the cast draft report review. 5, and this is of what the FBI did, cast final draft review. 6 is other geolocation data. 7 was the probable cause statements. And section 8 is the missing data. So in section 1, he explains to us that that's sure as shit. I just don't want to put some of this out there, that every single, so the Brian Kohlberger case was AT&T records. So AT&T will give you a case number. Then he goes and says, after that, I have reviewed approximately 300,000 geolocation connection data points associated with the records of Brian Kohlberger, by the way. And so what he did is he created the color red because he has this map out. And so he has everything overlaid. So he took Brian Kohlberger over the course of from June of 2022 until, November 16th of 2022. And all the movements of Brian Kohlberger are all in red, overlaid on a map. Then he took Maddie Mogan and did her. And she was, Maddie was blue. Okay. And so he outlaid all of the device's movements. Get this. The state did not do any of this. You can't even believe it. Then, and the reason for doing this is to see if Kohlberger had any interactions with the deceased leading up to the November 13th. Did they ever cross paths? So then he takes Xana's. Okay. And he does, and Xana's is green. Okay. And then they take, now, wait for this. Maddie Mogan's, Xana's. We get to Jack Showalter. And he takes Jack Showalter and makes Jack Showalter tan because he was a person of interest. Then we get to Kaylee. He takes Kaylee. And in total, there are 6,270 connections in this report. Her T-Mobile. And her color, Kaylee, was pink. So again, he creates the mapping of from June to November. And then after Kaylee, Ethan. Now this is where this blows. Ethan Chapin's report. It says case number unknown. I was like, what? It says, I was unable to find a complete set of records for Ethan Chapin, meaning. So in the discovery, you're supposed to be providing this. You could also hit up and do the power of the subpoena, and Ann Taylor can go straight to, Verizon. Okay. So here, this is the first time that we see this, and it says, I was unable to find a complete set of records for Ethan Chapin in discovery provided to date. I was able to find some different reports that indicated the CDRs for the device were obtained, and at least in part, some analysis was done in regards to common calls. Common calls, you guys. Common calls is to look at someone's phone records and to see if anybody has ever called the same number. That's what common calling is. is you look at, you have all these people, Xana, Maddie, so all the victims, and then, you know, Brian or whoever are your persons of interest, okay? And you're seeing, did any of these people ever call the same number? Did they have somebody in common? And I'm like, what? So as a result, because he didn't have the information he needed, which means the state couldn't do it either because they didn't have the shit. As a result, this device was not mapped in my analysis. You guys, Ethan has been the target of my investigation since jump because we need to know Ethan's whereabouts. Same thing with Xana. Then we get to Dylan Mortensen. And she's T-Mobile. So Dylan Mortensen. Dylan Mortensen's color is XXX because she's a victim. And so out of the mapping, you're not going to know what color is hers. Okay. And so Dylan's, though, we had Dylan's and he was able, you know, to lay it over the map, the same thing. Then we move to Bethany Funk. Verizon case number, unknown. Unknown. I'm like, are you got to be shitting me? Bethany Funk is unknown. Bethany Funk case. Look at every single person that he's been writing about is like 2 big paragraphs. We get to Bethany Funk and it's this little, similar to Chapin's records. I was unable to find a complete set of CDRs for this device. I was unable to confirm the existence of RTT timing reports. So just like now, Ethan Chapin's not in, neither is Bethany. I'm like, you got to be shitting me. Then we get to Molly McMichael. And I'm like, Molly McMichael was done? She was with Verizon. The original files from Verizon were not provided. Look at this. The original files from Verizon were not provided as discovery in this case. This may be in part due to the cellular data being captured by a third-party software, such as Penlink, because they like did a trap trying to pen and trace on her. There are 3 CV files that provided the captured network activity on this device. Then the location data associated with these files was not analyzed beyond identifying the type of data that was requested from Verizon and provided. More specifically, I was able to confirm that timing related data was requested in the search warrant, was subsequently provided by Verizon as a result of the court order. Then Jack Decor. Similar to Chapin and Funk's Verizon CDRs, I was unable to find original Verizon CDRs for this device in the state's discovery. I was able to locate RTT timing reports. This device location data was not included in my analysis. Hold on one second. So next. So Jack Decor wasn't added to the map. Now, section 2 is, hey, the methodology for review and analysis of the data. So he then lays out like, here, this is what call site sector the data is. This is what timing data is. This is what AT&T historical precision location information data, what everything means. So he breaks this all down, which is awesome and he would have done a great job with explaining that to the jury, right? Now, we can kind of pass by that because it gets brought up here. But in cases where all three types of data described above is available for analysis, all three types of data should be used for analysis. The different data sets can often corroborate each other, things like that. But in this analysis, I converted all the geolocation data described above into mappable files. So if you've ever watched one of Cyray's episodes, when he shows you how he takes basically Google, you can pump it into, and he did it in the, if you saw his testimony in the Fabio, it's the Monica Cementelli case. You're basically just moving this phone along where it goes this day, and then the next day, and then the day after that, whatever days you're doing. And it's developing a pattern of life for the phone, for the device. So I want to, so right here, the connections were synced to the data, and timing allowed the animation of device patterns over time. Each device was assigned to a specific color to allow anyone to identify and follow a specific device. Once mapped, I viewed each data set independently, as well as with other devices, to establish patterns of life and possible device interactions. As a point of concern, I am completing this report without the benefit of having received completed work from the state's expert. And remember, it's not supposed to work this way. The state had to get in their fucking disclosures. They did not. And that's when Ann Taylor was like, well, you want us to turn over my expert disclosures? That's not how this works. And so he's writing it here as it relates to methodology and opinion. That's what I do not have from them. Reports associated with the call detail records analysis are overly vague, incomplete, and generally contain no substantive value. Raw mapping files of, so this part I just, in working on criminal investigations for over 25 years, because it was extremely poor record management further complicates the issue, but 25 years. The evidentiary process used in this case is one of the most chaotic I have worked with. As such, it is possible some of the missing information data I refer to in this report exists, but I have been unable to find it. And it's like, wouldn't you ask them for it? And I'm guessing that they did, but hey, like in my analysis, I focused on the following: connections between Mr. Kohlberger and any of the deceased and or associates of the deceased. And that's the common call report. Now, I was able to locate sporadic files and reports that indicated a common call report was completed. However, the documentation is extremely poor as to what files were used, the method that was used, and the resulting work product. A common call report is an analysis that is done to see if there are any commonalities between phone numbers interacted with by Mr. Kohlberger to any numbers interacted with by any of the deceased. Like I said earlier, you're trying to see, hey, who was Brian in contact with that could be the same that the victims were in contact with? That's what that means. And Sai says, guess what, motherfuckers? Guess what? If my review is correct, based on the data produced to the defense, the only common number was a U-Haul dealership. A U-Haul dealership. And I was like, really? Brian called a U-Haul dealership? I'm just curious on when he made that phone call. Which is of no real concern, according to Sai, but I like to look into everything. I reviewed, so that means one of these decedents call the U-Haul dealership and that same line, because usually when you call dealerships, I mean, unless you're calling, you know how sometimes you can get that 1-800 number? Anyways, I'm just going to move on. I'm not going to get in my rant, but I reviewed all of the common CDRs associated with each of the decedents and Mr. Kohlberger from a time period of June 2022 through November 13th. In doing so, I am unable to find any common numbers. Now, geolocation data is a standard analysis that indicates when devices may have interacted directly by being in the same place at the same time. He was able to show on the Monica Simontelli case, just like you could show it any. Like, you guys weren't even just talking about being on the same goddamn cell towers, okay? He cannot put them ever at the same place, potentially ever, not once. To include the fucking crime scene, to include their house, meaning that he is able to debunk every single time that Nick Balance writes in his report of all of these dates that you're about to see, when Nick Balance was trying to say that it's consistent with being at the crime scene, meaning that he's stalking the house. So, with exception of slides 26 through 30 in the FBI cast final report, I am unable to find any documentation created or mapping files used of the attempts to conduct such a geolocation analysis. So basically what Sai's saying here is that they didn't track these people to see what their patterns were. In order to be able to say that you think someone's stalking somebody or that he was watching the house, whatever, you have to have work product. There is no fucking work product. The state didn't do dick in this case. It is outside of best practice in this field that an analysis would not have been done, thoroughly documented in a case of this nature. No different than the Tyler Robinson case. You want to start talking about that he scoped out UVU. You want to start talking about that he was going and going to places to take range shots to like prepare for this. You're going to do, like, your phone is going to show a pattern of behavior. My opinion is based on the following. Slides 26 through 30 are severely flawed and misrepresent the data. He's going to discuss that more in section 5. Statements presented in the probable cause statements without additional geological data, and for this very reason, misrepresent what is reported as facts of the case. Unbelievable. The inculpatory and or exculpatory nature of any findings connected to Mr. Kohlberger to any of the scenes is a cornerstone of this investigation. There is no evidence, mapping files, that have been turned over by the state to support any meaningful analysis on this topic, on this point. While I have identified locations Mr. Kohlberger and the deceased frequented in common stores located in a small community, right? Like Target, I am unable to pinpoint any time periods that may indicate any persons of interest could have come in direct contact with these common locations. Unbelievable. Do you know the lies that they have been telling? It's about to get way worse. I am unable to locate any period of time between June 23rd, 2022 and November 13th of 2022 where Mr. Kohlberger's mobile device is in the same specific area as any of the decedent's mobile devices. I am unable to identify any patterns that would be consistent to Mr. Kohlberger frequenting locations also frequented by the decedents. It is my opinion that the geolocation data I have been provided as of the writing this report does not provide any evidence of association between Mr. Kohlberger and any of the decedents and or Mr. Kohlberger's or decedent's residence. His residence. Their residence. Now notice how it's the decedents. My question to Cyree is, what about Dylan and Bethany? Oh, I see what you did there, Lana. Accuracy of geolocation mapping, specifically drive test data. As discussed in my synopsis, I was asked to review the accuracy of the FBI drive test early on in this investigation. Again, poor documentation conceals any real methodology that was utilized by the FBI in collecting drive test data or effectively mapping that data. As such, I conclude inaccuracies are clearly present in the FBI CAS final report. In an abundance of caution, I also performed an extensive drive test in the areas of Pullman and Moscow. This will be further documented in Section 2. Accuracy and completeness of mapping presented in the FBI CAS final report. It is my opinion that the state's experts have intentionally misrepresented the data in the FBI CAS report. It cannot be simply explained away as simple error or oversight. Further detail is provided in sections 4 and 5. The only people to do this was the federal government. That's who did the FBI cast and did all this shit. Nick Balance, Kennedy. You see the words intentional? Now, this was in the hands and could have been read by the judge. Now, think about now why Hippler and Ashley Jennings, Jennings, Bill Thompson, everybody, they had this, they saw this, and they knew we have to do what? And remember, that was one of my, I told you that would be one of my questions to Cyree is, wait, why don't you think that they muddied you up prior to trial and muddied up everything in the media on purpose? And that would show collusion. That would show concerted efforts, multiple people. Because how could Ashley Jennings ever write that motion thinking that the judge is going to just, shut down timing advance? I believe that Cyree's book is the biggest troll that we've ever seen. That's what I now believe. I believe that Cyree wrote his book as the biggest troll ever. Knowing that he knew that this report was going to come out, right? And I think he'll explain it in his interview. In conducting my analysis in this investigation, I also focused on the timeline of which information was obtained by law enforcement. The resulting legal process subsequently used to secure evidence and in the initial review and conclusions reached. As such, I noted the following. So you guys know me in the timelines. Ready? Early conclusions reached about Mr. Colbert's geolocation history is severely flawed and not supported by the data. Well, duh. Any meaningful, unbiased review of the data would have clearly revealed the errors. Mixed methodologies are present, indicating the investigators attempted to extrapolate certain details from the data while ignoring other details, creating highly flawed conclusions that were then used in probable cause statements to secure other evidence, which is the much larger issue. The magnitude of error is beyond oversight or incompetence. And now, if you go to Cyre's book, you guys got it. In his book, he says, remember, when you're doing your rules, you're assuming that the actors are acting, in good faith. Again, the magnitude of error is beyond oversight or incompetence. It appears there is an intentional effort to manipulate data for the benefit of bolstering probable cause statements against Mr. Kohlberger. This will be discussed further in Section 7. The term drive test refers to the physical act of taking cellular networking surveying equipment into the field to analyze cellular signals at any given location. By repeating this process over and over throughout an area, it is possible to determine cellular coverage areas with a high degree of certainty. The practice is well accepted by both in the engineering and network planning fields, as well as criminal justice applications involving geolocation analysis. Over the course of my career, I have performed hundreds, if not thousands, of these drive tests. I have always utilized the Schwartz TSMX network survey tools to perform these tests. These network tools are utilized daily by network engineers around the world. And so he goes into his background with that. FBI CAST utilizes a drive test produced from Gladiator Forensics. It is important to note that while the product is purchased through Gladiator, the internal survey equipment powering the tool is manufactured by Schwartz as well, what he uses, the TMS-M. Gladiator does utilize another software platform to analyze the raw data collected by the surveying equipment. Thus, there are two components to the drive testing. The physical survey equipment manufactured by Rohde & Schwartz and the software utilized to analyze the raw data collected. In my analysis, I utilized the Rohde & Schwartz Nestor software. FBI CAST utilized the Gladiator, the GAR software. Gladiator is a third-party company that makes software to assist law enforcement in analyzing geolocation data. They also provide software that analyzes drive test data. Again, see slide 8 of the FBI CAST final report for an example. The purpose overlay is the result of the GAR software taking the raw drive test data and creating an estimated coverage area. The blue dialog box represents, in quotes, when mapping the results of drive test data for one specific tower, the total coverage area for the tower sector is represented by the colored area on the map. So this is what Nick Balance would be testifying to, okay? And you're showing your little, see this area right here? Like this is what it's covering. Now, this clearly is not the case and can be easily proven. They attempted in this case to literally put in front of a jury incorrect coverage areas so that you could say, okay, hey, yes, my this person's cell phone is consistent with being on this tower, and that tower covers their home, or that tower covers 270. Okay, that's so think about how fucked up this is, that you manipulated to try to change the coverage areas so that you could say that Brian Kohlberger's phone is consistent with doing X, Y, or Z when it's fucking not. This type of manipulation you don't do when you have a mountain of evidence. So this little quotey poo here. The word estimate. So does not appear anywhere in the CAST FBI final report. It should be required. If one was to take the raw drive test data and manually plot the results on a map, most of the area represented by the coverage area has not actually been scanned. And I'm like, what? The GAR product takes snippets of drive test data and then uses an unknown, unpublished algorithm to estimate a shape allegedly perceiving or representing a quote unquote coverage area. Here are some examples that exposes this issue. Example 1, slide 27. From the FBI CAST final report, focusing on the lower portion of the coverage area depicted on the slide, there is no drive test data in the FBI drive test files to support this area. Most of the area represented cannot be accessed by a vehicle. So you could never have drove there to even test it because it's not drivable. You'd have to get your ass out of the fucking car. In mapping the raw data over the top of this shape, I found one small section of the road that was driven, but the rest was void of any data collection by the scanner. It is unknown the algorithm used by the GAR software to create such a shape. Additionally, in mapping the raw data, it was discovered more coverage area exists to the east and west of Highway 95 than what was represented on the map. Example 2 here is slide 13. From the FBI CAST final report shows 2 coverage areas depicted. One for South Side sector, and that's on the left. And this is the one that's on the right for this sector. Now, this one provides coverage to Mr. Koberger's residence, representing on this slide with the yellow label titled BK. There are numerous examples in the AT&T records where Mr. Koberger is known to be at his residence while his AT&T device is still using this cell site. By simply mapping Mr. Koberger's records, so all you had to do is map his records, it is easy to show this coverage area is extremely undersized, as some of the handoffs seen in the records are impossible based on this overlay. This coverage area should include the area around Mr. Koberger's residence. And so why would you ever change a coverage area? Why would you manually change and manipulate that? Well, so that you could say that in a fucking presentation to a jury, you could lie and say, see this area right here, this is where his phone's at, and this area is not consistent. That's not coverage area to his house, so he can't be there. If this doesn't literally put the fear of God, and I'm showing this here right now because of the Tyler Robinson case, they didn't show us any digital evidence. Digital evidence, probable cause, I mean, boom. That's probable cause in and of itself, because especially if you could show that Tyler Robinson brings his phone everywhere that he goes usually. These motherfuckers went, like, we're not talking about, like, wait till you see how they manipulated this data. Wait till you see how they did it. So now this sector here is flawed, as this is the area where the FBI scanner malfunctioned and did not collect LTE signals. Despite missing data, a coverage area was still plotted. This is an example showing the lack of confirming the results of the drive test before mapping them. Showing that you didn't do any of this prior to, like, your whole statement with probable cause. You couldn't have done any of this. If the missing data is added, this coverage area almost doubles in size. Example 3, this illustration is from slide 18 of the FBI CAST final report. It allegedly represents cell sectors this. This is the primary cell sector providing coverage to Mr. Koberger's residence. On the left side of the map, there is an area represented that is circled in red. The overwhelming majority of this area is inaccessible by a vehicle. The FBI will not be able to provide any data from the raw drive test file to support the mapping of this area because you can't drive that area. This is a more extreme example of an issue that is seen in nearly all of the coverage areas depicted in the FBI CAS final report. I'm like, are you fucking kidding me? The coverage areas represented in the FBI CAS final report and or the draft report are not accurate and should not be relied upon. More importantly, the attempt to use them in this manner with the added claim of the report being peer-reviewed is not within the norms of practice or training in the industry. A basic review of the raw data would have revealed the issues present and discussed in the above examples. Mr. Kohlberger's AT&T records alone show the accuracy errors, as handoffs seen in the records would be impossible based on the FBI coverage maps. That's why they were acting like the handoffs weren't existing, because it blew up their coverage maps that they created, to their false coverage maps. The fact these issues were not recognized and made into the final draft reveals a quality assurance piece is missing in the review process of this report. So it's not just Nicholas Balance. Nicholas Balance did this with Kennedy. It is both important and necessary. It is both important and necessary to understand the raw drive test data consists of nothing more than latitude and longitude points with network surveying readings. Any process that takes that raw data and converts it into a shape file beyond those latitude and longitude points should be subject to scientific review, because that's fucking crazy. In this case, the FBI CAS process to use the GAR program to make this conversion, I am unaware of and unable to find any scientific documentation by Gladiator on how this is done. I spoke with Gladiator Forensic Rick Semlock. He wasn't sure if there was any published data that could be reviewed to test any analysts, the results provided by the FBI team in this case. Because he was like, here, why don't you guys check it with your guys' shit? I followed up with a detailed email to Mr. Zemlock requesting any documentation they may be in possession of or aware of that would allow for independent testing and evaluation of the GAR mapping process. So, and cited this on purpose because he knew that what they did. So he went to, here, you guys, I'm going to go to GAR. Do you guys want to know what they're doing with your product? Do you want to know what the fucking FBI is doing with your product? Ready for this? Well, you think Rick here, good old Rick, wants to take on the fucking FBI? Who pays all of his bills? Fuck no. So what's Rick do? Well, he says, after he wrote him that email, Mr. Zemlock did email me back explaining the only document he could point me towards is the Gladiator patent. What? Patent number. Here you go. Here's the patent. The specific drive test files discussed here are, and list them out. They did one on 11/16/12/29, the day of his arrest, and 1/3/2023. They didn't do shit. This is like proof that, hey, you might want to know these dates, because when did they ever do this before they arrested Brian Kohlberger? Now, in the course of analysis, I noted the following missing data. Data is collected by physically driving the surveying equipment around in a vehicle. as with any surveying technique, it takes time to receive, analyze, and store the data being collected. This collection process and the time it takes to properly perform it requires the user or the operator to be mindful of the speed they are traveling and to monitor the equipment performance at the same time. But you would also know that if you just go drive around, speed all over the place, that's going to fuck up your shit. If driving too fast, the surveying equipment can fall behind and not properly collect the data required. In reviewing the raw data provided by the FBI, it appears this error occurred on at least one occasion. As a result, there are several miles of data collection that went missed. Coverage maps were created in both of the CAST draft report and final report that included the area where the missing data mentioned above is relevant. Given I can't find no evidence of the area being rescanned after they realized that here's your mistakes, because so basically what he went ahead and did is he's like, I assumed, given the coverage map was created, it is assumed that Special Agent Nick Balance and or Agent Kennedy were unaware of the missing data. This is assumed as it is logical to expect them to rescan the area in the event that they were aware of the missing data. Given I can't find no evidence of the area being rescanned, I must assume that they are unaware of their error. The error significantly impacts the purported coverage areas represented for this tower in both the draft and the final reports. The coverage areas depicted in the reports is significantly undersized by over 3 miles. Oh my God, 3 fucking miles. Are you kidding me? Oh, fuck. Steve Gonsalves, you think these feds care about you? They don't. They care about themselves. Unbelievable. Essentially, by attempting to create look at this. Essentially, by attempting to create a coverage area with raw data missing critical measurements, area of possible coverage cannot be considered by the software. This is a result of a user error in the drive test process. As a best practice, it is recommended operators monitor the surveying results in real time, like making sure and you're supposed to be driving the right speed. It's really not that difficult. As a result, the coverage area identified in both the draft and the final CAST reports is not accurate and should not be relied upon. This is further corroborated by the following. In Brian Colbert's AT&T records, handoffs are observed utilizing this repeatedly in the records that would make the purported coverage areas in the CAST mapping physically impossible. In conducting my own drive test utilizing the TSMA 6 and Nestor software, I was able to identify primary coverage areas for the eNode 424199915 up to 3 miles beyond the coverage areas depicted in the FBI CAST reports. I've been waiting for this to be able to say beyond a doubt. I knew that they manipulated the data. Okay. And I'm not a piece of shit and gonna go ask Cyray, hey, come on, tell me. Come on, man. Come on. No. I just knew that they manipulated the data. And I knew that they were going to try to say that to blame it on the error of the equipment, or once it's brought to your attention, then you have to do something after that point. But that's not what they did. They doubled down. And when you realize that they doubled down and they knew that they had already doubled down, that's why they went after Cyray. Now, but what Cyray did is he took out an insurance policy. And what Cyray did was he said, I didn't use any of my own shit. I went ahead and just used their data, their raw data, to show that this is all fucked. The mapping of the FBI raw data test data over 500,000 points further identified coverage areas well outside of the coverage areas depicted in the draft and the final CAST reports. Unfortunately, this is a critical error, as this is the coverage area referred to in numerous probable cause statements as being indicative of Brian Koberger's phone traveling away from his house in the early morning hours of November 13th, 2022, around 2:47. This faulty coverage area was reported as the last cell tower the device connects with prior to powering off at 2:47 hours, which is also an error in the CAS analysis. The phone does not power off until 2:54 and 45 seconds and is using the cell site sector that provides primary coverage to the Kohlberger residence at that time. He wasn't driving around when his phone was turned off. He was at his fucking apartment. They knew that. What they also knew is that Brian Kohlberger has a history of shutting off his phone. And anybody telling you different is lying. In addition to providing coverage to the Kohlberger residence, this cell site sector has one of the largest coverage areas for any cell site in Pullman. Remember how they made the FBI coverage areas are really, really small? The reason that they also did that is because it's actually way bigger, but guess which way it goes? The opposite way of Pullman. And they hid that part of it. So in addition to providing coverage to the Kohlberger residence, this cell site sector has one of the largest coverage areas for any cell site in Pullman. This coverage area extends for several of miles south of Pullman and includes the Washington State University Horticulture Center in the Bushby area. More importantly, this cell site cell sector does not provide coverage to Highway 270 between Moscow and Pullman. This is corroborated with the FBI's own drive test that reveals specific coverage areas for this cell site cell sector well outside of the Pullman area to include the WSU Horticulture Center. The fact Mr. Kohlberger's phone disconnects from the network while connected to this specific cell site cell sector eliminates any possibility of the device from being on Highway 270 between Pullman and Moscow at 2:54 and 45 seconds. This evidence proves that he is not any of those white cars, and significantly not the one on the Floyd camera at 3:02. Because it's now entirely impossible to get from where this coverage is in the matter of time from 2:55 to try to drive there and be on Floyd's at 3:02. You can't teleport. He used their own data. And that's why nobody could ever say to him in the courtroom, like, you're using your whatever the fuck bullshit that they try to pull, like this Z blah, blah, blah shit. Okay. No, I use your own shit. One cannot dismiss this error as oversight. The AT&T CDRs, along with the FBI drive test, make it incontrovertible that Mr. Kohlberger's device was not traveling east towards Moscow between 2:47 and 2:54. Any statements or diagrams proposing he was are false. To make such a claim, one must ignore all accepted principles of CDR geolocation analysis or omit critical data from the AT&T CDRs. impossible coverage areas represented. There are numerous areas depicted in the mapping that show coverage areas where there is no raw data to support the coverage. Basically, it appears the GAR software is taking snippets of raw data and then misestimating coverage areas. As an example, there are locations in the CAST mapping where less than 5% of a square mile had raw data collection. Yet the software estimated coverage for the entire square mile. Do you understand that what has just been uncovered right here, in my opinion, is exculpatory for so many people that have been put away for fucking CAST? Because of the CAST shit. Because of the way that it is explained in this report of how they went about manipulating the data. That you have to have a seasoned person and they have to do a lot of work. They've been doing this for a long time with CAST. The FBI got called out with this report. And because of this report, there's no way that this is go to trial. Now, I have a lot more to say about this. But I want to end on a really good cliffhanger because you guys can get really mad at me then. This is wild. This is sick. Basically, it appears the GAR software is taking snippets, like I just said, of the raw data and then misestimating coverage areas. Yet the software estimated coverage for the entire square mile, like I said, there is no published data that reveals the algorithm. Like, where are you getting this from? Even like, so we can fix it. Reveals the algorithm the GAR software is utilizing to make such estimations. And nowhere, and remember what he said, nowhere in any of these reports is he talking about estimated anything. They are talking about like that this shit, nothing was estimated here, and all these drive tests, like they drove everything. It's not estimated. This is facts. Boom. Standards in the field are that estimate and actual are not interchangeable. Talk about a big fuck you. Are not interchangeable words, you fucks, and need to be clearly stated. Conversely, slide 7 in the draft report and slide 8 in the final report define coverage areas created by the drive testing and give the appearance that they are actually coverage, not estimated. Handoffs allow a mobile device to seamlessly jump from one cell sector to another to maintain a constant connection to the cellular network. As a guided principle of handoffs, a mobile device can only hand off to another cell sector that is providing coverage to the location where the handoff occurs. Like, duh. In any given area within the network's coverage area, multiple cell sites or cell sectors provide overlapping coverage. In Brian Culber's AT&T cell detail records, there are thousands of handoffs reported overall in all of his shit. This is why I write bold as fuck right here. Wait till you see this. In analyzing these handoffs, there are numerous handoffs occurring in the records that would be physically impossible based on the FBI CAST drive test mapping. He is showing how many different ways this should have been caught by their own fucking people. But it was never going to be caught by their own fucking people because they truly didn't do a peer review. They did we need to fucking fix the records and we need to double down after. And that's what they did rather than just like acting like they made a mistake. Like, oh my God, we didn't even realize the GAR was fucked up. Nope. He gave them that opportunity in May of 2024, and he talks about it. His testimony in May of 2024 was, at that moment, the FBI knew that they were toe tagged, knew it. And so you can do one of two things. You can correct the error, right? Which would require you to admit that you never had probable cause, right? Or you could double down. And in order to double down, you would need protection in order to make the double down work. Otherwise, you're talking about careers. Like I've told you guys from day one, I said, this is career ending. And not only fucking career ending, we're talking about everything that the FBI cast has been involved in for these fucking convictions. This shit right here is calling it all, it's a recall. You would need protection from a judge. So in Brian Colbert's overall AT&T cell detail records, there are thousands of handoffs reported throughout. Like if you look at the data, in analyzing any of them, like if you did what you were supposed to do, this is why they never did anything of tracking where Brian was from June until November against where any of the victims were, because then it would out their own fucking map coverage areas in this big fucking problem, because they rearranged it all. And what those handoffs would show is that Brian Colbert is in an area where there's no coverage. It would out the different towers. So they knew that they had to stay away. They knew what they needed to stay away from. And so there are repeating handoffs seen throughout the records where overlapping coverage areas between two cell tower sectors must exist. Yet in the FBI drive test coverage maps, these cell sites, cell sectors do not overlap. The raw data does not support coverage maps. To better understand the software issues that are present in the GAR mapping, I manually mapped all of the raw drive test data points collected by the FBI. This was a tedious and complex task, and there are over 500,000 data points. This was done through a manual process and a program process to assist in double checking my work and reducing human error factors. In doing so, it was discovered the raw drive test data provided by the FBI does not support the resulting coverage maps generated by the GAR program. And so I'm over here saying, where did these maps come from? Remember, they kept asking them, where are these maps? Where'd you get that map from? Where'd you get that map from? There are clear areas of coverage in the raw data that are not present in the mapped data. Conversely, there are areas represented in the map data that are not supported by the raw data. When comparing the raw data I collected in conducting my own drive test, I found it was nearly identical to the FBI drive test. This is important to note. The raw drive test data is very similar, but the FBI's interpretation of that map data is clearly flawed. The errors described above are significant to such an extent it is difficult for this investigator himself to conclude that the FBI Special Agent Nick Balance and Special Agent Kennedy would complete such a work product without being aware of the discrepancies noted. It is the result of either sloppy processes and procedures, or the errors discovered are intentional. All the errors described and by the way, when he was talking up here, there's a footer. When he was talking about human factors, So then he comes down here and he says, I cannot find anywhere in documentation in the discovery where the raw data from the FBI drive test was ever reviewed. Meaning this whole peer review that you're talking about, everything that you provided us, whoever reviewed the raw data, it appears the raw data was loaded into the GAR program to generate coverage map shapes without any validation of comparing the raw data to the estimated coverage shapes created by the software. This is part of an analysis I would expect to see in the peer review process to confirm accuracy within the work product. Confirming accuracy within the coverage mapping is a common practice and an expectation of subject matter experts in this field. They know what the fuck they're doing. I will leave you with this. It is the result, like I said, of either sloppy processes and procedures or the errors discovered are intentional. All the errors described in Section 2 are in favor of the state. They're errors that favor the state. These aren't, there's not a single error, when you're making mistakes that fall the way for the defendant. Every single fucking error is in favor for the state. Wow. Like, again, talk about just such luck, right? So in Section 2 are in favor of the state and does conceal exculpatory evidence. There it is, on behalf of Mr. Kohlberger. This is a pattern that will be discussed throughout this report. And it is exculpatory. You want to know why? Because the entirety of their case depends on Brian Kohlberger leaving that area at that time, being that car to then the other car that's over there on Floyd, seeing on Floyd's camera, and then crossing on over, and then being the car that's at 326, and so on and so forth, with all their fucking bullshit. Well, Cyree is going to tell you that you cannot put Brian Kohlberger in Moscow that night. You can never put him at that fucking house, ever. With the data, every single piece of discovery, the FBI, nor any local, nor any state, nor himself, nor Tom, nobody can put Brian Kohlberger hanging out on the cell tower of the house, just watching it for hours, or even 30 minutes, 40 minutes. I mean, you cannot put Brian Kohlberger on that cell tower for any period of time over 4 minutes and 16 seconds. Ever. Everything is consistent with driving along and through the area to go wherever. And Cyree does mention where Brian Kohlberger's alibi is, and it is not Hawaii Park. I don't give a fuck about what Brian Kohlberger does or not. I care about my life. I care about your guys' life. I care about all the innocent people out here, right? All the innocent people who pay the government to do a job, who pay, the taxes to have jobs done, and who we need to have trust and faith in. And this report destroys that. And it absolutely destroys the faith in the courts, to include prosecutors and to include judges. And I am going to reach out, and I want Steve Gonsalves on my channel, because we're going to talk about this report. You want to go on all these other fucking people's channels? Steve, Christy, I want you guys on the channel. We talk. You guys know that I care so much about, what has happened here. I've been nothing but dedicated to the facts, getting the documents, But this report is not going to go untalked about. It's not going to be, this report's going to be answered to, because I won't stop until it's done. If you guys want to ignore this report, because you're putting your faith in the people that have been telling you things or the people that did this. And there ain't no fucking way if I have to exchange shoes with the parents that lost their kids. I have so many fucking questions. You guys are suing the balls off of WSU, and I hope you fucking win, and I hope you rake them across the coals. The police know what they've done. The prosecutors know what they've done, and the feds know what they've done in this case. And all they've done is lied to every single one of us, to include the parents. And here it's just right in front of our faces, and nobody. Brian Colbert taking a plea deal doesn't fucking change this. Period. It's not what it's about. For all I care, Brian Colbert can rot the fucking, if he wants to rot in jail for the rest of his life, I don't give a fuck. That's what he wants to do. That's what he wants to do. If Brian Colbert read this report and he was truly innocent and he has this report, then you have to ask Brian Colbert what the fuck he's doing. But that's not, I don't care about that. That's not my purpose. My purpose is all of us. All of us. We have constitutional rights. Brian Colbert had constitutional rights. Ann Taylor wanting to advise her client to take a plea deal. Hey. You guys, they did no investigation in this case. None. And instead, they just tried to omit and hide everything. Because all they care about in this fucking case is their goddamn little towns. They care about their schools and they care about their money. And we need this town to fucking run with the school. If the schools cannot run properly with Greek life and every other fucking thing that they needed to do, we can't have the school being, seen as a fucking, I don't know, a living, walking horror film. Because that's what it is. It's a living, walking horror over there. You guys, they just lied to me in a public request. They hid and omitted records on the night of the murder on who was working the plainclothes detail with federal money. They pulled documents from that and turned them over to me. They didn't realize I did it at the same time and asked the Idaho Drug Policy Agency for the same FOIA. And I got theirs back, and now I have them side by side. Who the fuck does that? Not people that are trying to be honest. Nobody fucking does that. That are trying to be honest. You cannot provide fraudulent public requests. That's a violation. And it's finable up to $1,000. I want to know if each time they did it to me, if it's $1,000. You know how many requests I have out there? So we're going to stop here and all these people lied. If Dylan and Bethany were guys, they would have been arrested. They would have been detained. They would have been actually interrogated. And if EWU doesn't step up their game with this lawsuit, with this, I'm filing though. I'm intervening because everything that they're going to court with, like, why would we do this all over again? I actually have the proof to provide and show that they provided fraudulent requests and that Eric Warner pulled shit from the files. And then he just recreated the file. What do you mean you recreated a file? He recreated a fucking document. And guess how they wrote it? He wrote it in black Sharpie marker on the bottom of the page. I've never seen more fucked up shit in my life than covering that case. And I think the Charlie Kirk case is the same way. So if everybody wants to continue on and thinking that there's nothing to see here in this Tyler Robinson preliminary hearing and in this case, I think you're wrong. This preliminary hearing featured no digital evidence, none. And I understand that the probable cause bar is so fucking low, okay? But it is one step over mere suspicion, people. And just go look on Twitter. The car is different. The person is goddamn different. The height is different. You have all those cameras there, and you don't have any cameras of nobody captured the shooting. Who cares if Tyler Robinson's allowed to be there? I have no idea why this defense team is being so adamant and trying to pit the media, like, and try to make it seem like the media is on the prosecution side. I'm not on anybody's side. But transparency is important, and I think that you should use it to your advantage. There's no, like, use the media wants to be there, be on your A game and present the information and use the docket the right way. And if your client is fucking innocent, right, you can preserve your client's rights. You can use voir dire to, there's so many different avenues to take to make sure that he gets a fair trial. In terms of this, it's a preliminary hearing. If you don't want certain shit out there, you have the right to waive that. Do you know how many guilty people do that because they want to plea down the road or whatever, or they're guilty and they don't want anybody to see that? So then what do they, hey, just, I'm going to waive my preliminary hearing but then speedy trial it. To take 10 months to for this shit that we saw, get out of here, man. They had that shit. Why are we waiting 10 months? And Erica Kirk and her attorneys are up there and they're saying the same thing that Steve and his family was saying. Transparency, we want it public. Go, do your thing. You know, stop hiding behind, like, show the material. Stop talking about conspiracy theorists online and that what they can do with the material, blah, 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 blah. Like, why are you focusing on everything that you're not supposed to be focused on? Do your goddamn fucking jobs and stop worrying about what the fuck we're doing. Hasn't anybody I swear, parenting is out the fucking window. Worry about yourself. Do your job. Fucking crybabies. All these motherfuckers. But here it is. This is the FBI. This is what they're capable of doing. And all they had to show in the Tyler Robinson case, you would think, is we have his DNA on the gun. The gun's in the grassy knoll, right? And let's just show a bunch of videos. Okay. But then you're not going to come and just, here's his phone. Very bizarre. Well, maybe they can't, because maybe we're working with a little fucked up situation. I don't know. And then that automated text that he's like, oh shit, I forgot to delete that. So if somebody just got into his phone and could have made and created that automated text that then led into the entire dialogue back and forth. You guys understand that, right? Which technically, right? I want to know where Tyler Robinson's phone was at 11 p.m. Lance lied. He said that I didn't talk to him at all that day until 11. That's a lie. Tyler texted you at 4:33 and you fucking answered it back. And so let me get this straight. 4 hours after he just killed and assassinated a man, he's writing you I love yous and to the moon and back, whatever the fuck bullshit y'all are talking about. You know, mwah, mwah, mwah. Pfft. That's a lie. He said he didn't wake up until 12 or 1. Okay. This is all a joke. It's pathetic. This is poor work. And to not bring these people in a preliminary hearing and have them testify, why? Are you telling me people are really concerned with their safety? I thought the bad guys in cuffs and in prison or in jail. So what the fuck are y'all scared about? That tells me that you can't be scared about Tyler Robinson. Peace out. Join me later because we about to get wild after this soccer game. Gotta go.